just to go back briefly to the discussion we had before lunch about siblings and parents, I just wanted to give an example that I've been given just to check that there's no confusion about what the position is. So if you have someone who is infected, say, at the age of 10, obviously now an adult, their parents are elderly adults now, but the infection took place when the child was 10 years old. The parent would qualify, or parents would qualify, as eligible affected adults.
Yeah, so they are parents of a 10-year-old child.
They were, at the time of the infection, they were parents of a 10-year-old child, yes.
Yes.
Yeah. And a sibling who, say, was an elder sibling going through A-levels, 17 years old, would also qualify.
Yes.
It might be said that by reason of the fact that of when that sibling's birthday was, they turned 18 in the course of that year, they might end up not qualifying because they've just turned 18 at the point at which the infection takes place, but may have suffered in exactly the same way, impact upon education and so on. Well, is there any answer to that?
Well, the answer is that you need to draw a line somewhere. We draw a line for all sorts of reasons about childhood finishing at 18. So it used to be 21, but it's now 18. So maybe you could change that. But I repeat that if you don't qualify by reason of your status, then you can potentially qualify under one of the other heads. So it's about a connection, and clearly it's not an area where there could only be one reasonable view taken. But that was my view.
And then can I just ask you to deal with the position of those who are both infected and affected? So, for example, where you have someone who, because of the hereditary nature of haemophilia, may themselves have been infected, but may also have lost or have cared for other family members. How would you envisage a scheme reflecting that?
Well, clearly they would be potentially eligible under both halves of the scheme. You would have to take into account the award under one and the totality of the award, so that you were receiving an award for the actuality of your experience rather than, putting it simply, if you've got a certain sum for an impact of your injury as an infected person, you couldn't double that up by having the same again as an affected person if the symptoms you're talking about are the same. So you would need to look at the totality of the event. So it is no coincidence that the categories of award I have suggested are, in terms of description of category, are fairly similar, whether it's there are more for the affected for reasons specific, but you would in effect end up with an impact award for the totality of your experience. I think that would be what would have to happen. So if you had a matrix, then you would have to adjust the figures to take that into account. But it'd be very difficult to do that by way of some algorithm. You'd have to have judgment as to what was fair in those circumstances.
So you would potentially assess that individual in their own right as an infected individual, yes. But then there would need to be a judgment as to whether additional compensation was warranted to reflect what they had lost as an infected.
Personally, the way I would do it would be to start off with the impact of the direct impact of the infection, and then the added impact, the aggravation, if you like, of being an affected person as well. And one could imagine that could be very significant.
Can I then just explore with you a little some issues that might arise in relation to claims brought on behalf of estates, or some form of quasi-fatal accidents act claim? It's been pointed out to me that not least because of the fact that so many years have passed, in many instances since an individual's death, that there may be all sorts of practical complications. There may be cases where there was no grant of probate. There may be difficulties in unravelling who would be the right individuals to bring claims. I'm not going to list all the various different permutations that have been drawn to my attention. But I'm asked to explore this with you. In Fatal Accidents Act litigation, there would be one claim brought on behalf of the estate, identifying the potential beneficiaries. Would you agree that that should, in principle, be the same for claims under the compensation scheme?
As far as possible, yes. Of course, that doesn't preclude direct claims from an affected person who's been affected by the infection of the deceased. But and I accept, of course, with something going a long way back, there can be complications which need to be looked at, but it is possible to appoint a personal representative, I think it's a proper word, or an administrator, to bring claims. But it's important that there is such a person. We can't have, I'm afraid, just everyone. You have to have a system by which there is a claim brought on behalf of the estate and then a mechanism for distributing any money that's received.
So there may need to be a practical mechanism under the scheme to try and ensure that potential beneficiaries are notified.
Yes.
And then potentially a method of allocation.
Well, yes. One can see there may be difficulties in. I mean, someone at some point has to identify the fact that the deceased person died of, or may have died as a result of this, and for the issue of a claim to be raised. And I'm not sure whether it's practical for the scheme itself to go hunting for people. It may be, but I would have thought it's more likely that inquiries should be encouraged from the relatives of a deceased person, and through publicity and other means. But the scheme should certainly be in a position to provide proactive help to such people when they come forward to navigate what is undoubtedly a complicated situation.
Yes, and I should say I'm not asked to put forward to you any specific mechanism, but just to identify that it's an issue that would warrant careful consideration.
For that reason, it's not one I've actually gone into detail about, because I think that's slightly premature until one's actually seen the overall structure of the scheme generally.
And then, relatedly, the next point I'm asked to explore with you is this. There will be potentially a not insignificant number of cases in which families will not have formally sorted out their estates, perhaps because there was so little in them at the time. And they will have to now go back and formalise the position many years after the event, with the prospect now potentially of more substantial sums being payable. If those substantial sums take the estate into the territory where tax might have been payable, do you agree there should be specific provision to ensure that they are disregarded for estate or inheritance tax? I
think I've raised a recommendation about inheritance tax generally, haven't I?
Yes.
And that should be the position, I think. I mean, it is a difficult, not an area free from controversy, but because if the compensation being received by the estate is for the injury to the deceased person, it might be argued there's no particular reason why that money should not be subject to inheritance tax, whereas money that's received under, as it were, the fatal accidents provisions for a dependency clearly wouldn't, I think, be under the Fatal Accidents Act, so shouldn't be in this sort of claim. But I think there is a potential issue around inheritance tax for, as it were, the compensation for the suffering the deceased has gone through. Because if a living victim receives compensation for their injury, as and when, if they were to die the following day, that money would be the subject to inheritance tax if it was of a sufficient quantity. So there needs to be parity there somewhere.
Would you agree that, consistent with the principles that you identified as the broad principles for the scheme, and the importance of making it something that can be navigated by individual applicants. Would you agree that there ought to be some form of appropriate legal assistance or support available, whether it's from the scheme or otherwise?
I think I've said that, in effect, perhaps in general terms, but where there are the complexities around estates, for instance, most people would not be able to navigate that without assistance, and the inquiry should be able to provide that.
The scheme should be able to provide that.
I'm sorry, not the inquiry. The inquiry does many things, but that's not one of them. No, I mean the scheme.
Can I then move...
Can I just clarify, through you, for the benefit of those who are listening, the current legal position on a death may be a claim of one of two kinds. Is that right? One under the Law Reform Miscellaneous Provisions Act.
Yes.
Long title, but basically that's a claim for the estate in respect of various events which may have happened during the lifetime of the deceased, where the deceased had an entitlement. Is that correct?
That is correct.
That is different from a claim under the Fatal Accidents Act, which is where some fatality, whether it be the consequence of an accident or a disease, has caused, in whole or in part, the death of the deceased.
Yes.
In which case the claim is not for the estate, it is for the dependents of the deceased.
Yes.
And what they get awarded in common law terms, or statutory terms, is a bereavement award, which you said earlier is set at a statutory figure which may not satisfy everyone, because it's neither so little that it is derisory, at least that's the theory. It certainly isn't generous in most people's perception, I suspect. Plus, the extent to which the survivors, the dependents who can claim, were financially dependent upon the deceased.
Yes.
And your scheme, as it were, cuts across both by giving them a recognition of the suffering they will have had, these are the dependents, the suffering that they will or may have had during the lifetime of the person who has died from an illness such as HIV, stroke AIDS, or hepatitis C.
Yes.
Plus the costs of care, plus the costs of that they have the losses they have suffered as a result, and the losses that the deceased suffered during his lifetime.
Yes.
I say his.
It might be her.
Might be her.
Yes. What I've sought to do, I think, is to not replicate, but sort of try and provide the equivalent of exactly what you've described in the scheme, so that there is the estates claim and a dependence claim, and a mechanism for doing that, but by reference to the, generally speaking, to the categories of award that I've suggested should be made.
Yes.
There was one other qualification, obviously in relation to a deceased person. One of the complications could well be some people will have provided for an inheritance in a will, others will not, and they'll be intestate, and there could be all sorts of potential complications coming out of either of those approaches, because, as we pointed out, a person who's made a will without any expectation of compensation might have made an entirely different provision to what they would have done if they had. I'm afraid the law has means of sorting that out. None of that is simple, and I don't think there's anything I could do to make it less complicated.
If there had been a Fatal Accidents Act and liability settled in court, there can only be room for one claim.
Yes.
Albeit that the claim is brought on behalf of a number of dependents.
Yes.
And that's to cut down the number of legal claims which may be brought. Would you envisage that the claims here, for those who might come within the categories of parent, sibling, etc., that they would be separate, divisible claims, or would they all have to be brought at one and the same time in effect by coming to the...
I think what I've suggested is that if at all possible, they should be brought as one claim in the same way, but each affected person who is eligible will have their
Separate
own
right.
separate right anyway. But clearly, I would envisage it would be better for the scheme, and indeed everyone involved, if all the claims of a family group, if one can put it loosely, were all brought at the same time and dealt with together, because there is likely to be an interdependence between some aspects of those claims.
Yes, thank you.
I want to turn to ask you a little more about recommendation 6 now. Recommendation 6 was the categories with defined degrees of severity,
yeah,
and the role of the medical or clinical advisory panel and the legal panel. Can I just ask you first of all about your thoughts on how the medical expert panel might be appointed? Would you agree that there should be a clearly independent and transparent process separate from government if the membership of the panel is to earn and retain the confidence and trust of those who might be affected by its decisions?
Well, what I think I envisaged was the arm's length body that I've suggested should be created, and obviously in the way of things that would have a board which would be an independent board, and I would envisage that one of their first tasks would be to appoint the panel, or panels.
And in relation to the medical panel, the clinical panel, would you agree that there would need to be robust conflict of interest safeguards in place, so that, for example, doctors who may in the past have themselves been implicated in their decision making which has caused harm should not be included on the panel?
There would certainly need to be a conflict of interest process. I am, from my professional experience, aware that there are certain areas, and I don't know if this is one, where actually the expertise is so confined that actually you have to take the expert where you can find them and take into account the fact that they have had experiences which are relevant to what you think about their judgment. But clearly, in principle, experts, whether legal or medical, should be independent and not have had anything to do with the history. But how possible that is, bearing in mind you're looking for real experts, I don't know. This inquiry, if I may say so, seems to have found a panel of independent experts, so it's not impossible.
In terms of the appointments to the legal panel, again, should be an independent and transparent process, so on your model would be undertaken by the arm's length body rather than
yes,
appointments by government.
Yes.
And I'm asked to put forward a suggestion for your comment, that perhaps approaching the editorial board of the Judicial College guidelines for the assessment of general damages, the JSB guidelines, for nomination might be a good starting point.
I'm not sure the editorial board of the Judicial Guidelines will necessarily thank me for that, but the Judicial College more generally might be a start, although obviously they know more about judges than they may do about the legal profession. I mean, there is frankly, it would be, I anticipate it would be much easier to populate the legal panel than it will be the medical panel, because there are a wide range of professionals, both at the bar and amongst solicitors, who deal with personal injury work of the type which would qualify them to make this sort of assessment.
Do you think it might be helpful to have on the legal panel at least one member familiar with either the inquiry or the detail of the suffering endured by the infected and affected, so that we're not having to reinvent the wheel?
Possibly, but I don't think I would want to legislate for that. I mean, yes, there is clearly, in both the medical side and the legal side, in order to make sure these processes happen expeditiously, it would be an advantage to have access to the learning of this inquiry, whether it's part of the report or not.
Now, I've been asked to explore with you the possible detriment of multiple assessments of individual applicants, bearing in mind what they've previously experienced. And maybe that question is based upon a misconception as to how the process would work, but I just wanted to tease that out with you. Let's say the medical panel have fixed their categories of mild, moderate, severe. The legal panel have filled the grid with a range of figures. In terms of the person or people who then decide where an individual application fits within that grid, like I think you said earlier, it could potentially be a lawyer, it could be someone trained by the arm's length body. You weren't, I think, prescribing who the assessors might be. But what information about the individual would you expect the assessor or assessors to have available to know where to place the individual in those categories?
I suppose the easy but very unhelpful answer would be as much as possible. I don't see this as being a process which you would probably find in some social security applications, to everything being reduced to a common form of 2 or 3 pages. I can see the job of assessment being quite onerous, and actually will need an examination of all the material the applicant would want to be taken into account, and anything else the scheme of its own ability has been able to find. I don't see any way of avoiding that process. But it's possible that one would hope the administration of the scheme would manage to collect the information in a way which would maybe in a standard form in the end, but which would be more easily accessible by the assessor. But it's a good reason, I think, why this is a process that needs to be undertaken by lawyers. And I now hark back to it a lot, but the 9/11 scheme had lawyers who did that. And they did interact with the claimants. Not in that case, obviously the claimants weren't, sadly, the people who had died, but the interacted with claimants and would interview them where necessary. So I see that as being a potential route to find out information that the assessor themselves would have, and probably should have, personal contact with the claimants, but not in the formal sense of a court hearing, but actually more of an interview. And actually, I think it's probably important that in order to develop that confidence and trust the claimants would need in the system.
So that there is no misconception, then, this process does not involve the medical panel undertaking individual assessments of the applicants. That's not their role.
No. I would like to think that the assessment would be possible on the back of the information available about the medical history. The point of the medical panel is to have provided as it were, a medical framework within which the assessor could place the information that is there. I would foresee that clearly assessors should have access to medical advice if there's something they didn't understand, or some gap that needed to be filled. And indeed, this, in one sense, has to be a developing process and a learning process, which is why I've recommended that obviously the scheme needs to be kept under review as it develops experience. And it needs to, of course, and publish reports from time to time, which make that clear to the world at large.
And so it may be, in an individual case, that the assessor might have all the information they need from the existing medical and other data that had been submitted to Skipton or one of the devolved schemes.
But clearly they would, in such a case, one would hope they would then seek to confirm that with, in terms of its accuracy, with the applicants and any other relevant people. And the scheme then would need to be alive to, as it were, absence of information and how to fill gaps.
And so there's no... right to understand, you're describing a relatively flexible approach in terms of the kind of information, evidence that might be looked at. Yeah. An individual who's provided a witness statement to this inquiry, that statement might itself provide ample evidence.
I would foresee this inquiry having fulfilled, amongst its many other valuable functions, the collection of a lot of information individuals might need to pursue their own claim.
May I ask a question? The process which you're describing is essentially this, is it, that at the very start there is a lot of work for the medical panel to do to work out what qualifies under the various headings, severe, moderate, mild, whatever the levels are. Once they've done that, those levels may need some adjustment, but essentially the hard work's been done.
Yes.
The legal panel will look at the categories and work out how much. And again, once that's been done, there may be a bit of tinkering later on, but essentially the hard work's been done. So that's a bit of, if you like, front loading.
Exactly.
In terms of the personnel and the time. The assessment has to be done by people who know the field enough to make a proper assessment, have sufficient training or background to be able to do it. By nature, is going to be a relatively limited class, particularly if it's going to carry confidence of those who are subject to the scheme. But their process is not a quick one, individually. And if, I'm just thinking to myself, suppose the inquiry did recommend a scheme such as yours, and at day one, invite applications. Now, there might be 3,000, 4,000, 5,000 applications, all of which would demand a degree of time flexibly applied to each of them. And yet the system has to be quick for the very reasons that you've described. How do you address that in terms of staging of this sudden rush, as it were, to get through the doors? Later on, it's much easier, because by then the great number who already have well-recognised, well-recorded claims will have been dealt with, and it's the new claims, wherever they may come from, that have to be analysed and looked at and assessed. How do you cope with the rush?
Well, again, there's almost certainly in this exercise got to be some front loading, because, as you say, there will be the bulk of people who think they have a claim already know they think they have a claim, and they will be waiting there anxiously for day one to put their claim in. Obviously, the efficacy of the scheme will depend on whether sufficient funding is put in and resource put in to enable a sufficient panel of assessors to be recruited. And I would envisage that sensibly, when at the start, it may be slower dealing with an individual case than it becomes later on when it's more used to. But I do point to the fact that it's not impossible. The 9/11 scheme dealt with all 3,000, 4,000 claims in 2 years, beginning to end. So, and I admit that some of that might have been, sadly, more simple, because they weren't talking about lengthy and varying medical conditions in the way that this panel, these assessors would. But I'm rather assuming, and I hope rightly, that once the understanding of the range of medical experience is described, that it should become quite easier for actually the individuals themselves to seek to fit themselves into categories, and for the information they produce to be designed to that end, and a system to be devised so that the information can be processed relatively quickly, but depending on the nature of the case. A lot will depend upon collaboration, the willingness of people perhaps to accept something that's a bit more broad brush than they would do in a court-based system. But I would be confident that, I mean, obviously there has to be a prioritisation of cases, and you either take first come, first served, which is probably the fair thing to do, or you look at urgent need, and you might want to do that. But I would assume that my recommendation about an interim payment has been made, which would relieve the pressure. And if you don't have an interim payment of sufficient substance, and the figure I put in is clearly just a potential figure, but of sufficient substance to allay people's fears that they might not be actually getting a fair compensation, then I would see there's a problem. But if that's provided, then the pressure is a little bit off in terms of how long things take.
I was going to ask if this were in itself a reason for thinking that there may be something to support the interim payment scheme.
Yeah. Well, I do. One of part of my thinking about it was that the interim payment itself should be of sufficient substance that actually it might reflect at least the substantial part of quite a lot of people's claims. And I don't put it no better than that. There are clearly going to be claims which are way in excess of that. But if the figure is one which some people might actually be satisfied as being actually that's all they need or want or whatever, then that will in itself relieve some of the pressure. So that is one of my reasons for recommending an interim payment.
Yes, thank you very much.
You referred this morning to the approach to self-assessment in the Scottish scheme,
yes.
the SIB scheme. Is there, again, building on the principles in particular that you identified, collaboration, ideas of trust and so on, is there something to be said for having self-assessment at least as a significant feature of the scheme or a starting point for the process?
Well, I think actually self-assessment is almost an essential part of the process in that it's the beginning of a conversation, isn't it, as to what people regard as their position within this framework. So I'm assuming that the framework is described in language that people can understand. They know what their own experience has been, and they can put it in. And what impressed me about the Scottish scheme was that, as lawyers are sometimes accused of being cynical and sceptical and so on, a lawyer of such a mind might have thought that everyone would claim the maximum and say we're the most severe cases. That's not been the Scottish experience. So, of course, it is a starting point, and no scheme could possibly just accept the self-assessment without question. But it is the beginning of a conversation and a reference point. So, yes.
Again, picking up on that idea of a conversation, would you anticipate, ideally at least, that the conversation continuing with the assessor saying either having looked at the material, having helped the individual gather any additional extra material, my assessment is the same as yours, or my assessment is different, and here are some thoughts. Yeah. But do that as a staging point in the conversation. So before getting to any formal final decision and then formal review or right of appeal, that the assessor might say, I think you're in this category for these reasons. What do you think? Because obviously if that can be resolved by agreement, dialogue, discussion, that reduces the burden on the individual and reduces the burden on the scheme.
Yes, ideally that's what should happen, and it's why I'm very keen that this should not become an adversarial process as between a scheme which is trying to save every penny it can and a claimant who, dare I say it, backed by, supported and represented by some lawyer, is claiming the maximum theoretically possible, but both sides are seeking to come to a reasonable solution around the circumstances of the case. That's a much better way of producing a satisfactory outcome than an adversarial system which it produces an analogue answer, yes or no, or this figure or that figure.
Can I then ask you a little about recommendation 7? So could we have the report back on screen, page 35, please, Lawrence? So recommendation 7, bottom of the page, refers to aggravated and exemplary damages, and you say in the recommendation, A, the scheme should allow as part of the autonomy award for eligible infected persons an award equivalent to aggravated damages for the aggravated distress caused by interferences in their autonomy and private life, such as lack of informed consent, information about the risks of treatment and about diagnosis, treatment and testing. And B, the issue of exemplary damages be reviewed in the light of the findings of the inquiry. Now, again, just really for the benefit of those listening, and you've explained the terms in your report, but could you just briefly explain what aggravated damages are and what exemplary damages are.
Yes, I'll do my best. The idea of, if I can deal with exemplary damages first, is it's a punitive award. So it's an award in a court system of the court's disapproval of the conduct, usually of a state body, but it may be others, and the misconduct, as opposed to a value of the injury that's been suffered. So it's a bit like a fine, but it's one that goes to the claimant. There are other jurisdictions where exemplary damages are awarded by juries in the United States in millions of dollars a lot of the time. It's a much less common feature of claims in this country. The Republic of Ireland compensation scheme, from memory, allows for exemplary damages and indeed has a special fund for that. I didn't feel qualified on what I knew to say yay or nay to exemplary damages. All I would say about it is that it would undoubtedly introduce an adversarial element to what would otherwise, I hope, be a more consensual, collaborative scheme. And a way of dealing with exemplary damages would be to say, well, if that's what you want, well, then try your luck in court, because it's not compensation. In reality, it's a punitive element. Aggravated damages, on the other hand, to my mind, could play a part, which is where the injury has been aggravated by conduct or something else that's unacceptable. And in the case here, it seemed to me that from what I was hearing and from what I've read, that one of the things that a number of people, many people, are complaining about has been an interference with, in effect, their human rights, interference with family life, interference with their autonomy in terms of consent and other ways, which they would say has been completely wrong. And that has aggravated, in a real sense, the injury they have suffered, and in some cases in itself caused considerable psychological distress and sometimes mental illness. And it was for that reason I thought that that was something that could be reflected actually in the autonomy award. That's really the purpose of having something over and above the social impact award, which was about the direct effect of stigma and other things, which exist regardless actually of the conduct of this type. And these are concepts that are quite difficult to express, but I think much easier to understand when looking at the stories that I heard and are available to the inquiry.
And so, in relation to exemplary damages, is this right, that a key reason why you have not made a recommendation of it is because, in your view, it would essentially turn on findings of misconduct,
yes,
pejorative critical findings about the role of the state, and that's the job of the inquiry rather than you?
It is, and it also fits, in my view, rather uneasily into a scheme which is meant to be about compensation and a scheme which is meant to take the place of, because it's broader than in some ways litigation. So in one sense you might say that the need for exemplary damages is at least reduced, whatever the findings of the inquiry, by the fact that there is this scheme in existence to remedy what has gone before. That would be one thing. But it would be, I think it fits it's quite a difficult thing to fit into a collaborative scheme where you've got assessors looking at medical histories and all the rest of it, and then suddenly having to switch into deciding on what degree of culpability is involved, and is it so, what any individuals happen to them is so bad that the state should be punished by giving extra money to this particular individual as opposed to all the other victims of this particular disaster. So that's my problem.
Just before we move to aggravated damages, do you know what kind of circumstances have triggered an award of exemplary damages in the Irish scheme?
I'm afraid I don't. I have looked at a number of reported cases, because they don't report the actual tribunal cases, or if they do, I couldn't find many of them. They do report the appeals to the court. And I think some of those have been about aggravated damages, but I'm afraid I don't have a sufficient understanding to be helpful to you on that. But I know what I do understand from the system is that there's a separate fund for it, and I think there's a separate process of determining it. So it undoubtedly adds complexity to an already complex system in Ireland.
In terms of the aggravated damages as part of the autonomy award, what's your suggestion or expectation as to how the scheme might go about calculating the level of aggravated damages?
Well, I think it's difficult because it's not. These are damages which are related to the interference with a right, or a failure to protect, if you like, is another way of putting it, rather than any actual sort of physical or mental injury. So it's rather like if you brought a claim for a breach of human rights under the Human Rights Act, for a breach of the right to privacy or inhumane or degrading treatment, there would be a level of award for that, which is assessed in part by reference, and how much longer that will be possible, but at the moment is assessed in part by reference to cases in the European Court of Human Rights, and where awards are made just for the very fact that a right has been broken. The awards, I have to say, tend to be relatively modest. Most people would say, I don't think say that's right or wrong, because as with so many things, there's no right or wrong answer. But I would envisage these would be relatively modest awards because they would be on top of awards for things that actually do not sound in damages in law in this country at the moment. So we are already suggesting that people should be compensated for, in effect, psychological injury in circumstances where they probably wouldn't get that in litigation. That might be said to be another way of reflecting aggravation, which wouldn't conventionally be seen. So I would envisage relatively modest awards here, bearing in mind everything else that such a person with such a claim would have.
And when you're, again, talking about relatively modest, is it right to understand, and I have in mind here the kind of awards that are made in Strasbourg and occasionally made in these courts, you're talking about something more than in the hundreds of pounds, but something less than in the tens of thousands of pounds usually?
It might be in the tens of thousands of pounds. It certainly wouldn't be in the hundreds of thousands, no.
And
nothing is certain, obviously, is it? But that would be my vision of it, yeah.
In terms of the kind of items that might trigger it, lack of informed consent, lack of information about risks of treatment, being tested without consent, would you envisage potentially, or would you recommend a tariff for that, X £1,000 for testing without consent, X £1,000 for being involved in research without consent, or would you envisage a slightly more flexible, holistic assessment?
I think it would probably be fairer or more manageable anyway to set an overall range, which this wouldn't be a matter for the medical panel. It would be a matter for the legal panel, I think. After all, there would need to be a difference, it seems to me, between someone who on one occasion had not been offered informed consent from someone who'd spent years being subjected to testing or experimental treatment without being told about it. So there's a sort of scale of aggravation. And I think some of this, anyway, would, because these circumstances will have given rise to additional distress, the distress caused by the suffering from either the injury, the infection itself, or the treatment from it, we'd still be talking about relatively modest sums, but I think there'd be a scale, and it would be something which would have to be worked out in practice, I think, over a period of time. And my reservation about it as a whole is that I could see it giving rise to a lot of dispute over a relatively small proportion of what would otherwise be a significant award, but we would have to see. But I see the case for it.
And then we talked about the significance and the problems created by missing medical records in the context of establishing eligibility. The same kind of issues might arise in the context here of establishing testing when
Yeah.
a patient wasn't informed and so on. Would you, again, in broad terms, envisage a similar kind of approach as previously, so that the assessor would not be sitting as a tribunal of fact, would not be interrogating the medical records, would not be calling for evidence from the clinicians, but there'd be essentially an extent of having regard to the findings of this inquiry on the broader issues, and then perhaps taking on trust, having regard to the credibility of what's advanced, the applicant's account of having been tested without consent or not given information.
Well, very, very much that, I think. And I would expect that the evidence of this inquiry would be such as, or evidence before this inquiry to be such as to establish patterns which could be taken into account. And I think also it might be relevant to note that whether or not any individual had been tested without their consent, if it was the circumstances are such that everyone might fear that without knowing, that in itself it might need to be reflected in an award. But obviously, if it was possible to show these specific insults in a technical sense had occurred, then that would make for a stronger case.
Can I turn then to consider next recommendation 8? So if we go over to the next page, please, Lawrence. So we're now looking at the heads of damage, or heads of award, I should say, for those who were infected.
Yes.
And we have the 5 components there set out. In relation to the impact injury award, you've already explained how you envisage that happening with the role of the medical panel and the legal panel and the creation of the tariff and the grids. Would you envisage the same in relation to the social impact award?
I would, but the difference would be, clearly social impact is not a medical matter, although clearly clinicians, and we can see this in the expert report, are well versed in noting some of these impacts. There is also the psychosocial evidence. I see this as an area where it would be more appropriate to come up with a standard figure, by which I mean not the same amount is given to everyone, but there is a standard sum which refers in part to the length of time that an individual has suffered from the impact. Because it's one thing for an individual to have suffered 1 year of stigma and then die. I don't want to be cruel about this, but that may be some cases, whereas others, we're talking about a lifetime, 40, 50 years of this. So there would have to be a reflection of time and so on. But I would think that it's an area where perhaps less regard should actually be paid to individual circumstances. And I say that for this reason. I believe, from what I've seen, that the stigma and to some extent general social consequences of these diseases is such that everyone who's contracted them will have suffered them. How they suffer them will differ from case to case. So it will, at one extreme, people may have lost friends, lost family, lost jobs and so on. At the other end, none of those things have happened because they kept everything quiet to themselves. It seems to me to distinguish in money terms the value of one of those from the other would be artificial. So, and it seems to me that the way in which these things are received, in a sense, matters less than how long they've been received for. But again, there will be potential grades in this because, or could be, but I think essentially we're talking about a standard figure that everyone would get and would know what it is they get referable to the length of time they've suffered from this from.
Can I just ask you about the table on page 107 of the report, again, so that there's no confusion about what the significance of this table is.
Yeah.
So just before we look at the text above it, the table itself, it says illustrative periodic figure for the impact of stigma and social exclusion. And this table envisages that there might be different social exclusion stigma awards for different infections.
Yeah.
Certainly
Possibly.
Certainly for different periods of time, and you've explained the rationale for that. In relation to different infections...
I didn't feel... the reason I've not been more specific is that I frankly didn't feel able, in what I saw, to work out for myself whether HIV was a worse, in inverted commas, category than hepatitis C, or whether they're all much the same. And so I think that would be an area perhaps someone would need to look into.
That's really the purpose of going to this.
Yes.
You are not positively advocating that there should be distinctions based upon the different disease. You say in terms in paragraph 9.48, that would have to be something that is decided by the expert panels.
But my instinct was there might be a difference, and it was also my instinct that if you had both, there was a co-infection, that might be worse. But I wasn't sure about that.
And then just if we can go back to the table, again, this is an illustrative
It's very
table.
much so, yes.
This suggests that the impact of stigma and social isolation could mirror the categorisation of mild, moderate and severe.
Yes.
Does that necessarily follow? You may have had the stigmatising impact of whether it's HIV or hepatitis C or hepatitis B may not depend upon the severity of the underlying condition and the other experiences that the individual might have suffered in terms of side effects of treatment and so on.
Well, maybe, but on the other hand, someone who has had 15 years of symptom-free life, for instance, followed by a period where these things come to life, or a period post-infection of an undiagnosed and symptom-free period, is unlikely to have suffered as much stigma, in fact none, until later on. So there is I think there's a case for saying that there will be different degrees of severity.
But does that suggest that the length of time may be more significant than the course that the illness has taken? Or is your mild...
It's both. I think it's a mild case of hepatitis C, if there is such a thing, and you may tell me there isn't, but if there is such a case, then there will be a level of stigma, particularly if there are long periods of no symptoms, where life could be relatively normal. But if we're talking about, as opposed to someone who is visibly very ill from these awful diseases. So I just put that forward as a possible way forward. And it may be there aren't very many cases at the mild end in this, but it just seems to me one needs the option there. But I do think that the length of time it's suffered for is a significant factor.
Just going back then, we can take that down for the moment, Lawrence, to the injury impact award, where you do envisage the categorisation potentially into mild, moderate, severe. Did you have any expert or other advice available to you about the feasibility of constructing that kind of tariff system?
No, only only in terms of these particular diseases.
Yes.
No, not. And it's not a question which was answered, obviously, by the evidence that I saw, unless I missed something. But it does seem to me, from what I read, that there are some cases that are more serious than others. I mean, obviously, there are people who happily do not develop liver problems. There are many who don't get cancer. There are many who've had a relatively symptom-free time, albeit with worry maybe and treatment and so on, whereas others have had terrible symptoms for long periods of time. So there are degrees of severity, to the extent to which they can be classified and described. If you ask me that, no, I'd had no expert advice on that. But frankly, certainly as lawyers, we spend our whole time looking at conditions like asbestosis or pneumoconiosis, which may be one condition but affects different people in different ways, and evaluating that and coming to different values. All I'm seeking to do here is to try to collect and classify, or get cases classified into more categories so that it is easier and quicker to make awards than it would otherwise be.
So would it be right to understand, you drawing on your broader experience of how compensation is assessed more widely, it may not be easy to describe those categories, but it ought to be possible to do so.
And I do visit, it's insofar as this may actually not be exclusively a medical matter, and I think I say somewhere probably not prominently enough, that I don't necessarily see the medical and legal panels operating in isolation all the time. I can see there being an interchange between them. So, as would happen in a court case, the lawyers and the judge would be consulting the medics about the nature of the condition in a way which makes their evidence relevant to the assessment of damages. So I wouldn't necessarily expect that the medical panel to be able to come up with this without dialogue with the legal panel.
Again, I'm very conscious that you're trying to describe a scheme that doesn't take forever to get up and running. But would there also be a role on this really very important issue of how you categorise cases, a role for consultation with those infected and affected?
Definitely, it's absolutely essential. And indeed, and you would probably expect me to say this as Chair of Health Watch and the President of the Patients Association, they should be involved in the creative process. This is not an area where I would be terribly happy with two panels going away in private and coming back 6 months later with a proposed solution and having a 6-week consultation over the summer holidays to produce the results. You need some real involvement, because as with everything else, but this scheme in particular, it needs to carry the trust of the people who are most deeply affected by
it. I was going to come on later to the issue of a final award or provisional damages, but it might be sensible to address it now. You referred to someone who, when you're talking about how you might distinguish between different categories of cases, there may be somebody who doesn't currently have cirrhosis or has cirrhosis but hasn't developed cancer, hasn't required a liver transplant. But if we take hepatitis C as an example, the same may well be true of the other conditions with which we're concerned. There are significant elements of uncertainty about future prognosis, as sadly only too many here in this room will know. And so somebody may have a level of cirrhosis now, but may develop in a number of years cancer. How does that fit with a final scheme rather than provisional?
Well, I come back to that. There is a choice to be made here. In the court situation, in litigation, until a provisional award of damages became possible, it was always the case that the court had to make a once and for all assessment at the point of the case about an injury, including the prognosis for the future. So damages will be awarded for, in effect, the risks of deteriorations in the future, which, the degree of those risks would obviously depend on the medical evidence. So, by definition, a one-off payment is never right, because firstly, if it is a lump sum, there's an issue about how long people live, and so no one lives precisely to their statistical expectancy. And secondly, some people will develop the risk and some won't, and so that some people will be overcompensated, but some will be undercompensated. The advantage you get in return, though, for that uncertainty and that broad brush approach is you have finality and you know where you are and you don't have to keep on revisiting these things. And the strong message I was getting from people is that a lot of them want that finality. The choice of having a provisional award is that, and which exists in the court system now, is you could have an award which assumes the best, in effect, and then define certain deteriorations which would allow you to come back for more. And of course, a compensation scheme could do that. The reason I've not suggested it, but of course it could be done if there's a powerful enough view about it, is that it adds complexity, it adds costs. It means that individuals can never let go of the system because they will always be thinking we might need to go back for more. So they've got to retain records, they've got to retain the ability to make good their case, however collaborative the system is. And then you ask the question, how often can they come back? Do you have a series of provisional awards? Now, again, the Republic of Ireland system does allow, I think, for awards of that nature. They don't, again, I think the figures are available in their reports as to how often that happens. I think it's a minority of cases. But you could do that. The life expectancy issue is taken away in relation to anything you award a periodical payment for. So you can now precisely compensate someone for the length of their life because that's what a periodical payment does. But there is a choice to be made. And to put provisional damages as a provisional compensation as a thing would mean that people remain a member of a scheme, which actually they prefer not to be. I mean, people like the support payments because they carry on getting them, they don't have to do anything more about it. And I thought that's what would attract people. But of course, you could have that option in there if you wanted. It would be a burden on the scheme. It would therefore cost the scheme more money. And the issue is whether it would deliver more by way of justice to people, and I think that's open to debate. So that's my reason for it anyway.
In your report, if we could go back, please, to. Sorry, let me find the right page. Yes, page 103. So we've got a table here at the bottom,
yes.
Illustrative grid for an impact award by categories of severity. And so this is the injury impact element of your recommendations. Now, again, important to understand, these are not the figures that you are positively asserting should be used by the scheme. This is for the purpose of illustration as to how it might work. Is that right?
Yes. Where I have a little more confidence in these as figures would be the upper end of it, in the sense that I sought to reflect what seemed to me to be the reference point being the maximum payments you're likely ever to get for pain, suffering, loss of amenity as an award in a personal injuries case. And then coming back a bit, because serious though these injuries undoubtedly are, they're not, I'm afraid, they're not the really most serious injuries, and it's difficult to conceive, but they're not. And so one has to put that in the scale, because it does seem to me that whatever is awarded here should bear comparison with what, in this particular category, with what people might expect to get in litigation. So that's the reference point. But the figures are overall illustrative rather than a recommendation, as it has to be, because I'm not judging it against any particular case.
No, and on your model, it would be the legal panel who would work out what the figure ranges should be in each of these categories. And one of the sources that you've suggested that they might wish to draw on are the Judicial College guidelines. Yes. Could we go to page 151, please? First of all, could you just explain for the benefit of those listening what the Judicial College guidelines are?
Yes. The Judicial College, as its name implies, is an organisation which trains judges. There was a time when it was thought judges were born to be judges and needed no training whatsoever. Fortunately, we're now better advised than that, and every judge has to go through some training. But one of the college's functions that it now performs is through a committee of experienced judges and lawyers, is to offer guidelines as to the amount of damages to be awarded for injury. And they do that by reference to decided cases, what the guidelines said before, and when new things come up, they look at those. And then they set a range for each injury as is described, and then that gets uprated for inflation every year until they look at it again. So on the bench, any judge who's trying a personal injury case will have the Judicial College guidelines. They will be referred to other reference points as well, but by and large, it's the bold judge who goes outside the guidelines for an injury that is mentioned in these guidelines. Now, of course, they don't cover every circumstance, as is illustrated by the sad facts we have here. They don't deal with these particular injuries. But what lawyers do is they take, when it's a case like that, they look at something that probably produces a similar type of suffering, and then they put that together. But one thing that doesn't happen is that if you have one accident, you have a broken knee and a broken hip, and you look at the guidelines, you don't necessarily just add them up and get the total, because the suffering from the two, as we all know, if you have a pain from your knee and a pain in the hip, it all tends to end up as one pain, so you get a figure for both together. So that's how it works.
And if we just take an example, if we go to page 160, this is mesothelioma and then ASPA. So if we pick it up on the previous page just to make sense of it. So we've got asbestos-related disease. There's then a description of the range of diseases that might be due to asbestos. If you go over the page, we can see there, just in relation to the top half of the page, there is a range given there of just under £60,000 to £107,410. So would it be right to understand that the way in which these kind of guidelines might be used in the assessment of damages, those representing the parties would look at them, the court would look at them, and would then do their best to identify where within that range the individual case fell? Exactly.
And by the way, the bold print is mine, not the guidance. It's just I occasionally saw stuff that I thought it was worth drawing attention to. And the reason for including mesothelioma is it's a long lifetime condition with severe consequences, including death, but also producing the need for surgery, chemotherapy and radiotherapy, which, and therefore is comparable to some of the treatment needed in our cases. And as you see, the maximum there is 100. Now, the figures are very peculiar and specific because they're the result of uprating for inflation. At some point, it started off as a round figure, but has now become artificially precise, many might say.
And if we just go back to page 151, you've referred here to the 15th edition, the 2021 edition of the Judicial College Guidelines. Now, you weren't, as I understand it, using this prescriptively in any event.
No.
But I'm asked to explore with you because of the use that might be made of the figures in your report and this. Presumably, whether it's the government looking at your recommendations, the arm's length body setting up its scheme if one is commissioned, the panels looking at it, or individuals assessors, they should guide themselves to the extent that they're going to look at the Judicial College Guidelines as a source and only one source. they should look at the most recent version.
Oh, certainly. I'm not sure that if the 2022 edition hasn't actually already come out.
It has.
It
That-
has.
that's the
I think
purpose of
it
the
came out
question.
more or less as I signed off this report, much to my
It came out
irritation.
in May, in fact, so a
Yes,
few weeks
okay.
after your report.
You know, you've got to stop somewhere. But you're absolutely right. We have to use, or they should use, the up-to-date editions. And indeed, the figures, there would be, where occasionally in these guidelines, a significant change is made other than a rate of inflation, because there's been some case that has seen a different perception in something. And that would be one reason why any figures they come up with probably need to be kept under review.
And would it also be right to understand that, again, looking at it from the perspective of a court, for present purposes, being the principal user
Yes.
of these guidelines, that a judge, when deciding on the equivalent of the injury impact award, the general damages for pain, suffering and loss of amenity, will potentially increase further by reference to the current RPI.
Oh, yes, I'm sorry. Yes, my pause was whether it is still the RPI or now something else, because there's the CPI, the Consumer Prices Index. I think it depends.
So the important
But
point,
there is a rate of clearly the rate of inflation. We uprate these figures, and we are now unhappily back in times of inflation being more than minimal. So this would be paid attention to in some detail in a court case. Yes.
and probably should be something that the scheme or the panel would themselves have
Yes,
in
it
mind.
would, well, it would be possible to have in the rules of the scheme that it would automatically uprate things by reference to whatever index they referred to.
Sarah, I note the time, perhaps a good moment for the afternoon break.
Yes, that's a good point at which to break. 3:45. 3:45.